for the general awareness and I think sobriety of the pro-life movement moving forward. Like you've said, I've had conversations in my extended family and community about this where there are celebrations that these big abortion clinics are being shut down, and it should be celebrated, right? Every clinic that can no longer murder unborn children being shuttered is a good thing. But you're right. I mean, the sobering reality is that most abortions are chemical. I think it's something like 2/3 of abortions in the United States happen chemically and not surgically. So it's important to note that if the actual intent of the pro-life movement is to stop abortions, then these abortion pills and chemical abortions are the correct target. This is just where it's happening. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week we're going to cover a Department of Justice intervention in a lawsuit over mail-order abortion pills. Then we'll go to an appeal to the Supreme Court by a pro-life student group alleging censorship of speech. And we'll finish in Massachusetts State Court with a case currently in the Supreme Court there over the placing of religious statues on public property. So in this first case, we're going to turn to the Department of Justice's recent intervention in the case involving the state of Louisiana versus the FDA. So as most of our listeners know, the state of Louisiana, like several other states after Dobbs, bans nearly all abortions in their state. However, various pro-abortion groups and individuals from states where abortion is legal, like New York and California, regularly mail abortion pills to states like Louisiana to their residents on a regular basis. So this practice is largely enabled by a 2023 FDA change in regulation that eliminated the requirements for an in-person doctor's visit as a requirement for the delivery of the abortion pill mifepristone. So in order to protect its citizens from continued injury caused by the abortion pill, by the 2023 policy, and also to protect Louisiana's ability to actually restrict abortion, which is its law and its policy, Louisiana sued the FDA, sought an injunction and the vacating of that regulation with the intention that it would reinstate the in-person requirements for dispensing of the abortion pill. So the FDA was responding to this lawsuit. It's been going on for a while now, but the FDA, along with the Department of Justice, recently weighed in to this lawsuit, asking the court to delay its ruling until after the FDA has completed a safety review of mifepristone. So this is an ongoing review. It is a positive review of mifepristone at the FDA level, but the date by which this will be done is unspecified, and I think that is the real controversy here. So just worth noting that the request to delay the outcome of this case has incited a lot of criticism from pro-life organizations. The FDA just approved a generic version of the abortion pill late last year, which is a concerning signal to pro-life groups that the FDA is not really aligned with pro-lifers on the dangers of this medication. So among others, Marjorie Dannenfelser from the Susan B. Anthony list released a statement that the federal government's request undermines pro-life states by delaying this lawsuit. Leadership at Americans United for Life also criticized the move, calling this a contradiction of the administration's promise to protect life. So here's what I see. First of all, as Joseph, I know you pointed out in our email, our weekly email that's going out, the damage caused by mail-order abortions, it's immediate, it's immense, it's constant, and it requires swift action, right? These abortion pills are being mailed into states where abortion is illegal all the time on a regular basis. And so this 2023 policy by the FDA basically enables abuse and coercion, allows women to get these pills that have some pretty serious health risks besides the death to an unborn child, and to do so through the mail without an in-person doctor visit. So I would say, on one hand, the Louisiana lawsuit has an ability to immediately stop the 2023, it's often called a REMS, right, a risk evaluation and mitigation strategy, so the change to the regulation, because this REMS has eliminated the in-person dispensing requirement, allowed these mail-order abortion pills to take place. But if the lawsuit goes through, that regulation would be vacated and or enjoined today, right? Like the date that the court weighs in. So it would save lives. It would immediately stop these abortion pills from flowing over the border into Louisiana or at least make it illegal for that to happen. Hopefully that would actually stop it. And it would effectively end the abortion by mail regime that's undermining the policies in pro-life states, right? But on the other hand, I will say, I understand the argument, but I will just say that this move by the FDA is not, it doesn't look to me that it's clearly an anti-life attempt to keep the abortion pills flowing into pro-life states like Louisiana, because I believe the intent behind what's going on at FDA, I could be wrong, but is to actually backtrack and remove the 2023 regulation and reinstate the in-person doctor visit dispensation requirement. So again, I don't want to minimize this. This would slow down the process. This would, pausing the lawsuit would create more time where mail order abortions can be sent to places like Louisiana. But I'm at least hopeful that the intent of the FDA is to eventually roll back this regulation. But I will also note that the Louisiana lawsuit doesn't just challenge the law on procedural grounds. That's one of the claims, right? That the particular regulation in 2023 is arbitrary and capricious. The way that it was done violates the law. But there's also a greater argument in the lawsuit that abortifacients can't be mailed under the Comstock Act. So actually this regulation is just unlawful. So this lawsuit wouldn't just undo the particular regulation, which could be redone under a future administration, right? This would clarify this lawsuit that the mailing of abortion drugs is unlawful on broader legal grounds than just the particular circumstances that led to the 2023 regulation. So I'm hopeful that this will go forward and have a good resolution. I'm hopeful that the administration is trying to come to a pro-life outcome and repeal this 2023 regulation. But in the meantime, I mean, this lawsuit is an opportunity to say that no, the regulations weighing in and allowing mail order abortion pills without doctor visits, this just violates the law and can never happen. So I hope we get a good resolution, and we'll stay tuned and see what the effect of this request is for a delay. But Joseph, I'd love to hear your thoughts on this.
Yeah, thanks for explaining what's going on. I have two quick things I want to add. For one, I just want to take it as a chance to point out the scale of the use of mail order abortions and mifepristone. You know, it's great to see abortion clinics starting to close their doors because they're getting less traffic and they lose funding. But across America, the total number of abortions hasn't really gone down since Dobbs, and it's in large part because of the prevalence now of these abortion drugs. In the court documents, some of the pro-abortion groups in this lawsuit are sending hundreds or thousands of abortion pills every month into individual states. So I mean, every single abortion is a huge issue. The scale of the use of these abortion pills is also just massive. And the one other thing I'd like to point out is that, typically speaking, a court order is typically stronger than like an FDA regulation. Right? That's one big reason you said. There's a couple others, like how for the time that this lawsuit is still going on, abortion pills are still being sent. That's one big reason that pro-lifers might want this case to go to court. That's another. As a court order is probably going to be a bit stronger and last a bit longer than just a change in reg, right? The FDA's policy, let's say they do, after they complete this review, say we're going to reinstate the in-person requirements for someone to get the abortion drugs. In a few years, a new administration could come in, make their own review, and say, actually, we don't need these requirements anymore, and just get rid of them again. Now, of course, the court order could only apply to this one particular policy, and it's kind of limited in its scope. But it's something that you can point to and say, actually, a court has said that, this is the order that's come out. So there are other reasons this case can and should proceed, but the fact is a rule in here that reinstates the in-person requirements likely lasts longer than a new FDA policy that does the same.
Yeah, and I just would point out, because you make a really good point there for the general awareness and I think sobriety of the pro-life movement moving forward. Like you said, I've had conversations in my extended family and community about this where there are celebrations that these big abortion clinics are being shut down, and it should be celebrated, right? Every clinic that can no longer murder unborn children being shuttered is a good thing. But you're right. I mean, the sobering reality is that most abortions are chemical. I think it's something like 2/3 of abortions in the United States happen chemically and not surgically. So it's important to note that if the actual intent of the pro-life movement is to stop abortions, then these abortion pills and chemical abortions are the correct target, because this is just where it's happening.
Yeah, absolutely. Thank you for kind of bringing more color to that. So with that, we'll change gears and talk about our second update, where a group of pro-life students that recently appealed to the Supreme Court were censored because of the association's posters. So for the facts, a student in Indiana, anonymously referred to as ED because she's a minor in the court documents, she started a chapter of the Students for Life of America at her public high school, right? This is a pretty mainstream pro-life group for young people. And at this particular school, student associations aren't sponsored by the school, but they can put up posters throughout the school hallways. They can use school property to host their events, but they are distinct and they're not actually like school sponsored. But in order for them to put up these posters, they have to go through this process where they get permission from the school administrators. So the student that started this pro-life chapter, sought permission to advertise the chapter's first meeting, and the signs had language like defund Planned Parenthood. They had pictures of people from the march. And unfortunately, citing an unwritten ban against political content, her request to put up these posters was denied. And even further, actually, the principal shut down her student association despite previously saying, you can start this group. So basically, the student starts a pro-life organization, tries to put up posters. Once the principal sees them, he says, actually, we're not going to do this, and shuts down the whole group. So ED, with the help of attorneys from ADF, sued the school board on First Amendment grounds. And after the Seventh Circuit ruled against her by applying a very broad interpretation of Hazelwood that we'll get into, she recently appealed to the Supreme Court. So I want to spend a bit of time explaining the core legal arguments here, because if SCOTUS takes this up, it could be arguably the most important ruling on student speech in public schools since the 80s. So this is ultimately a case that's really all about when schools can restrict first speech without violating the First Amendment. And there's two relevant precedents in this case. There's Tinker and Hazelwood. So some listeners are probably familiar with these. We've talked at least about Tinker in the past on the podcast, but just kind of briefly to set the background here. So Tinker is a 1969 case that really sets the floor for protecting student speech in public schools. Basically, they're a group of students planned to wear black armbands in order to protest against the Vietnam War. School administrators sent a few students who wore the black armbands home for doing so. Those students sued, again claiming a violation of their free speech rights, and the Supreme Court ruled in the students' favor. Very famously, the court wrote that students do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Basically, since the armbands didn't, and this is kind of the operative language in Tinker, they don't substantially interfere with the work of the school or impinge upon the rights of other students, the school couldn't punish kids for wearing these armbands. That's kind of the big test that came out of Tinker, basically. If the speech doesn't substantially interfere or impinge upon the rights of others, the school can't regulate it. So Tinker sets the background, but what's really being debated in this case is Hazelwood, which was from 1988, basically the first school speech case after Tinker, and it cabined some of the broad protections that Tinker gave for school speech. In Hazelwood, some students schooled a public school after it cut their articles out from a school newspaper, and the articles were writing about the students' experiences with pregnancy and divorce. Basically, the principal felt that some of the content wasn't appropriate for younger kids, or there was some privacy concerns about other students or parents being identified in the articles. So he said, I'm going to pull these out. We're not going to publish them in this article. And then the students who had their articles cut sued the school again, First Amendment claim. And there in Hazelwood, as opposed to Tinker, the Supreme Court actually ruled in favor of the school, largely because the journal that the students were claiming their free speech was violated by removing their articles from was actually part of the school curriculum. Basically, the journal was produced as part of a journalism class in this school. So really, a key part of this case that we're seeing in the one today in Indiana comes down to a few phrases and a few interpretations of Hazelwood. So coming back to the dispute before us now, where the pro-life students were censored because of the content of their speech, the student lost at the Seventh Circuit because of Hazelwood. And in this particular case, the Seventh Circuit said that since a reasonable observer could erroneously interpret the flyers that contained, defund Planned Parenthood and different pro-life speech, since a reasonable observer could construe these as school-sponsored speech, the school can control it and take it down. They're saying that in Hazelwood, the Supreme Court justified ruling in favor of the school because, quoting from Hazelwood, members of the public might reasonably perceive the speech to bear the imprimatur of the school. So basically, the Seventh Circuit saying that Hazelwood says that if somebody, a reasonable observer, perceives that speech within the school could be sponsored by the school can regulate it. And several other circuits have ruled similarly. It's like a roughly 4-2 circuit split here. Basically, that schools can control speech that a reasonable observer might incorrectly believe to be blessed by the school. And this test sounds a little bit like the logic of Lemon. This is pointed out by the cert petition, which the court has famously now long since disavowed. Where basically the Lemon test, again, probably pretty familiar, but part of the logic of that test was whether a reasonable observer in an establishment clause case would consider the government's challenge action as an endorsement of religion. Now, the problem with the Seventh Circuit's decision here is that that's not the operative distinction that Hazelwood makes. Hazelwood was about not if an outside observer could, see something as school-sponsored. It was about if the content of the speech or the speech itself is part of a school's curriculum. That's the operative distinction there. Is it curricular speech? Other circuits apply Hazelwood only to speech that is part of a curriculum. And that's likely a more accurate reading, really because throughout the opinion in Hazelwood, the distinction is this part of a curriculum? Even just the first sentence of the Hazelwood opinion, the justice that wrote the opinion writes that this case concerns the extent to which educators may exercise control over the contents of a high school newspaper produced as part of the student's journalism curriculum. Even the sentence directly after the imprimatur phase that the Seventh and other circuits rely on to justify heightened control of speech. The next sentence again doubles down that the speech can be regulated, quote, because it's part of the school curriculum. So really in Hazelwood, the key thing is the speech that's regulated part of curriculum? If the answer is yes, there's more deference to schools to regulate it. If the answer is no, they're probably not going to be able to. So tying it all together, just to kind of summarize here, in this case, a public school shut down a pro-life student's speech because of its content. Now, Tinker broadly protects student speech that isn't substantially disruptive to the school activities or doesn't impinge upon the rights of other students. About 15, 20 years later, Hazelwood clarifies the Tinker decision by stating that schools can still control speech that's part of its curriculum. Today, several circuits are split over how broadly Hazelwood applies. Here, the court used a reasonable observer test, asking if a reasonable observer could misconstrue the speech as school-sponsored. However, this is highly unobjective. This type of test misreads precedents and subjects students to ideologically motivated censorship in spaces that should be designed to foster open debate and conversation, or in the Supreme Court's own famous words, the nurseries of democracy. So, Frank, that's what I've seen. That's kind of the breakdown. I'd love to hear your thoughts on what's going on here.
Yeah, I think you covered the major legal analysis really well. I think there's definitely a problem. We've covered some of these school speech cases a little bit before. I forget what the case was, but a couple of months ago we talked about this. But here, it just, you look at the precedent and the actual facts in cases like Tinker and in Hazelwood, and there's just not a lot there to make you think that a student group that is obviously not affiliated or sponsored by the school putting up advertisements to somehow look like it's the speech of the school. It's just not what's going on here. I think it's pretty minimal. I think also you can distinguish from Hazelwood that there was a concern in Hazelwood about whether the content was age appropriate. They were talking about their experiences of pregnancy and divorce, and is that really something we want to have school age children hearing about? That doesn't really come in here. Defund Planned Parenthood is certainly age appropriate for high school students who are already being exposed to all kinds of adult material on a regular basis. So I think that argument's pretty weak. But overall, I think you do a great job on the baseline question of when and how public schools can restrict political speech in general, right, in a neutral way. But I would also say, and I don't have any evidence here, it's just a question, is I would be very curious to see how evenly these kinds of policies are applied, right? Given the prominence of DEI issues, Black Lives Matter over the last almost 6 years now. These have been huge issues among young people, right? Protests and things like that are a very common dialogue about these kind of issues. So I would love to see whether, student groups that have ever engaged with race issues that are, maybe Black Lives Matter supporters or whatever, have they ever advertised or spoken on issues like this in their student groups or events? And has the school refused, or would the school refuse them from, putting up a poster that says Black Lives Matter or something like that? Because then at that point, it's no longer a question of we don't allow political speech. Then it becomes viewpoint discrimination, which, again, I don't have the comparison test case. I don't know that this school has ever encountered that, but I would be very curious to see how even-handed school districts are applying policies like this.
Yeah, I know in this particular case, this was the first time that the principal actually said this student association can't exist anymore after he had already given permission for them to kind of get started. And there's like a Republican Republican Students Association or whatever at the school. There's a Democrat Student Association. There's other more kind of social issue sorts of things. And this is the first time that a student group has had actually gotten their permission to operate revoked after the content of their speech was disclosed.
And just to be clear, the reason that this group was disbanded and the request was denied was the citation of a ban against political content by a student group, correct?
Yeah. There's no definition of political written, but in all the documents and in the principal's correspondence with the student, it was always, well, we ban political speech, so sorry.
Yeah, to say that this pro-life group can't speak because you've banned political speech, but then to have like a Democrats and a Republicans club, I can't imagine a scenario in which the Republican club or the Democrat club exist and don't engage in political content in any of their speech or events. So that just kind of gives a little bit of ammunition to support my thought there, I think. All right, now let's move to state court. We're going to finish up on our last topic here and talk about Massachusetts. So this is interesting, and I think it's a good case to highlight a common federal constitutional issue applied to a state constitution. So what we have here is most of our listeners probably know this because I know our listener base is predominantly, they're not exclusively Catholic. So Saint Michael has long been the patron of police officers as well as military personnel. Saint Florian is the patron saint of firefighters. These are often used as motivating figures for police and firemen. As you noted, Joseph, not on the recording here, but even in non-religious spheres. And I think everybody kind of knows this, right? Like you can get, the military T-shirt brands that'll have like Saint Michael and I will fear no evil, the little quote on the side. And these are not religious T-shirts. This is like military gear. As you've also pointed out, the Florian Cross is a marquee symbol of many fire departments. International Firefighters Day is actually on the Catholic feast of St. Florian in May. Many police departments award St. Michael's awards for acts of valor. So these are very established symbols of the police and fire, respectively. So in order to honor and inspire, first responders, the city of Quincy in Massachusetts, the mayor planned to install statues of Saints Michael and Florian at the entrance of the city's public safety headquarters. Again, symbols of those departments make sense. Some residents, unsurprisingly, filed a lawsuit to prevent installation of these statues, citing an article in the state constitution that prevents the government from favoring one religion over another. In a sense, we'll get back to that. So there was broad support from the city's police and fire departments. They signed on, in this case actually, as amici in support of the statues. State courts granted the injunction and prevented the putting in place of these statues. So recently the Massachusetts Supreme Court agreed to hear the appeal. Beckett is representing the city. And so Beckett looks at some past precedent, makes some good claims that this Massachusetts equivalent of the Establishment Clause, this is a quote from Beckett, does not require the complete obliteration of all vestiges of religious tradition from our public life. And they go on to quote a case from 1979 from the Massachusetts Supreme Court, as well as some provisions of the state constitution itself. So I think there's a pretty good argument here. I think this will be an instructive case, although I don't know the makeup of the Massachusetts Supreme Court. I don't know how sanguine I am about the outcome of this particular case, or whether this will, if Massachusetts rules against the city here, whether this is something that SCOTUS might look at. But I just wanted to point something out. This is, in some sense, a very common theme that we've touched on here, right? Opponents of religion using, on the federal level, the Establishment Clause to try to basically keep any vestige of religion out of the public square. But this one's unique because it's relying not on the Establishment Clause, but on a state constitutional equivalent. So the relevant portion of the Massachusetts Constitution reads, it's not the same as the Establishment Clause, which is relevant, and I'll read it here. All religious sects and denominations, demeaning themselves peaceably and as good citizens of the Commonwealth, shall be equally under the protection of the law, and no subordination of any one sect or denomination to another shall ever be established by law. So here I think we do run into the same ideological issue from opponents of religion that we get with the Establishment Clause fights, which is this. To simply have religious symbolism in the public square, such as these two statues, it's not the subordination of any one sect or denomination to another as established by law. It's just not what this means. I think Beckett's argument in their brief bolsters this point, and I'm going to read at length here from their appeal brief because I think this bit is really good. So the brief says, for example, the preamble to the Massachusetts Constitution, drafted by John Adams, acknowledges the goodness of the great legislator of the universe, his providence and his direction in allowing the people to form a new constitution of civil government. Article 2, also drafted by Adams, explains that it is the right as well as the duty of all men in society, publicly and at stated seasons, to worship the supreme being, the great creator and preserver of the universe. And Article 3 itself, which is the one in question here, as amended, but the essence is the same, says that the happiness of a people and the good order and preservation of civil government essentially depend upon piety, religion, and morality, impressing the importance of the public worship of God. So again, looks to me like another attempt to say that any placing of religious symbols or any support of religious programs by the government is somehow an imposition of a religion above other religions. To use the same example I've given in the past, you have to take this much farther for me to see a constitutional problem, right? If Quincy puts up these two Catholic statues, but then a Protestant group comes up and says, hey, we have a patron of libraries, of whatever, of some other department, and we'd like this statue, there's popular support among people in this field, we would like this statue, and the government says, no, like we have these two Catholic statues, but we're not doing, the Methodist or the Baptist or the Episcopalian tradition, like, no, we don't accommodate that. Then then probably we do have a subordination or establishment issue, right? There's the subordination of one religion to another, but I don't think that the placing of statues of St. Florian and St. Michael, which on one hand are Catholic symbols, and even that I think is non-problematic, but as you pointed out, Joseph, and I said earlier, there's so much non-religious or non-specifically Catholic historical significance to the figures of Saints Florian and Michael that I don't even think we're close to the line of subordination or establishment here. Just seems like a non-issue being litigated by opponents of religion in the public square. I think I'll leave it there and hear you out on this, Joseph.
Yeah, absolutely. Thank you, Frank. And like you said, the fact is, from the American founding, religion has been part of public life. Right, Frank, I love the quotation from the Massachusetts Constitution from Adams that you referenced, right? That the happiness of a people depends upon piety, religion, and morality. It reminds me of his other famous statement that our Constitution is made only for a moral and religious people. It is wholly inadequate for the government of any other. And even today, religious imagery is present all over government buildings. Right? Moses with the Ten Commandments is carved in the facade of the Supreme Court. The phrase "in God we trust" is in both the Senate and House chambers. Bible verses are carved into the blocks of the Washington Monument. So, Frank, like you explained, the law supports the city's ability here to install statutes of religious figures to inspire first responders. And just this effort to whitewash our society of all references to faith runs contrary to both our law and our history.
Yeah, I think that's right. And I think this will be an important case to see. Like I said, I'm not particularly optimistic that the Massachusetts Supreme Court is going to come down the right way, but then I do wonder if you have a free exercise issue or what's going to happen from here if this is something that the U.S. Supreme Court would take up. But again, this is another issue that is ongoing and we will be keeping on top of in the weeks to come. So with that, we thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you listen from. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you all next week. Thanks for joining us, and God bless you.